You probably heard about this multi-billion-dollar lawsuit that was supposed to totally shake up the real estate industry. Well, it just hit a massive legal wall. A judge's recent decision has thrown the whole thing into question. And today, we are going to break down exactly what happened and what it all means for the future of buying a home.
So, you've got this colossal lawsuit, billions of dollars on the line for home buyers, and it just slams right into a judicial roadblock. The big question is, why? What in the world happened to stop this thing dead in its tracks? Okay, so here's the bottom line. A judge just handed a pretty significant victory to the National Association of Realtors, NAR, along with other big names like RE/MAX and Keller Williams. They managed to get a key part of this lawsuit thrown out. But, and this is a big but, this victory might just be temporary. To really wrap our heads around this, we have to untangle a bit of a legal mess. See, this whole situation doesn't revolve around just one lawsuit. It's actually about two massive lawsuits that got all twisted together.
On one side, we had the Burnett case. That one was brought by home sellers. They argued that the industry rules forced them into paying unfairly high commissions. In that case, it's already been settled. On the other side, we have the Batten case. That's the one in the spotlight today. This one was brought by home buyers, but they're making a very similar claim about those same inflated commissions. So you see what's happening? Two different groups, but they're both pointing their fingers at the exact same industry practice.
And this right here is where things get really, really messy. According to the plaintiff's own data, a staggering 79% of the people in the home buyer lawsuit, the Batten case, are also members of the group that already settled the home seller lawsuit. This massive overlap is the legal grenade that just went off. Okay, so here's why that overlap is such a killer for their case. When the home sellers settled that first lawsuit, the Burnett case, the terms were crystal clear. You can't go and sue again for the same thing. But then, whoops, nearly 80% of them show up as part of this new lawsuit. From the court's point of view, that's a huge no-no.
Yeah, and a spokesperson for NAR did not pull any punches. They basically said, look, the homebuyers' lawyers tried to build a case where almost 4 out of 5 individuals weren't even legally allowed to be there in the first place. For a judge, that is a gigantic red flag.
So this whole mess lands on the desk of Judge LaShonda A. Hunt. And it's her job to step in and try to untangle this complicated legal knot.
Now, to get what the judge did, we first need to understand a term called class certification. Think of it like a group pass for a lawsuit. Instead of thousands of people filing thousands of individual cases, the court gives them a permission slip. It says, okay, you all have the same complaint, you can sue together as one big team, or one class. Without that certification, these massive lawsuits are basically dead in the water. And that certification is exactly what the judge went after. Because of that crazy 79% overlap, she struck it down. In plain English, she said, nope, this group, as it's currently put together, cannot sue as a team. It's fundamentally flawed. But, and this is probably the most important part of this whole story, she did it without prejudice. Now, that's a fancy legal phrase, but what it means is super important. It means that even though this attempt is blocked, the door isn't locked forever. The homebuyers' lawyers are allowed to go back to the drawing board, fix their mistake, and try again with a new, corrected group that doesn't have that overlap.
So let's just recap what the judge did. 1. She struck down the proposed class. 2. She stopped any moves to change the case schedule. And 3. She essentially slammed a giant pause button on the entire process. The lawsuit's forward momentum has come to a screeching halt until they can sort out this fundamental issue of who is actually in the class.
So where does this leave everybody? Well, let's be clear. This legal battle is definitely not over. It's just entered a new and, frankly, much more complicated phase.
So here's what the road ahead looks like. Mark your calendars for November 24th, 2025. By then, both sides have to go back to the court with a joint plan for what's next. Then, looking into early 2026, an appeals court is going to hear arguments on a related issue that could also shake things up here. And hanging over all of this is the big question. Will the plaintiffs try to refile their case with a brand new, legally sound group of homebuyers? At the end of the day, this whole thing boils down to one critical challenge for the homebuyers' legal team. Can they successfully carve out a new class of plaintiffs that is completely separate from the group that already settled the Burnett case? Their entire multi-billion-dollar claim now depends on the answer to that question.
And that leaves us with the big multi-billion-dollar question, right? Is this ruling just a procedural speed bump that some clever lawyering can get around, or is it a fatal blow that could bring one of the most significant lawsuits in modern real estate to a grinding halt? Only time will tell.